Georgia gives landlords broad freedom to set and raise rent, consistent with the state's overall landlord-friendly regulatory approach. The governing law is found in Georgia Code Title 44, Chapter 7, which covers landlord and tenant relations. And while it establishes the basic framework for the landlord-tenant relationship, it places no restrictions on the amount a landlord can charge for rent. Georgia does not have rent control or rent stabilization of any kind. There is no state statute that caps rent increases, limits the frequency of increases, or requires landlords to obtain government approval before raising rent. Georgia's political and regulatory environment strongly favors property rights and market-based pricing, and rent control has not gained meaningful legislative traction in the state. Georgia has enacted a preemption statute that prevents local governments from enacting rent control. Under Georgia Code Section 44-7-19, no county, municipality, or other political subdivision can enact, maintain, or enforce any ordinance or resolution that would regulate the amount of rent to be charged for the use of private residential property. This means Atlanta, Savannah, Augusta, Columbus, Macon, and every other Georgia municipality are legally barred from implementing rent caps. This preemption is particularly significant given Atlanta's explosive growth and the intense affordability discussions that have accompanied it. Atlanta has experienced some of the most dramatic rent increases in the Southeast, and without the preemption statute, there would be enormous political pressure for local rent regulation. The preemption ensures that the market-based framework remains uniform across the entire state. For month-to-month tenancies, the landlord must provide advance written notice before a rent increase takes effect. Georgia requires at least 60 days written notice before changes to the terms of a month-to-month tenancy, consistent with the 60-day termination notice period we discussed in our Georgia lease termination video. So if rent is due on the 1st and you want the increase to take effect on June 1st, you need to deliver the notice by April 1st at the latest. Georgia's 60-day notice period for rent increases is longer than the 30-day standard used by most states. This gives tenants meaningful time to evaluate the increase, adjust their budgets, or begin searching for alternatives. While the 60-day requirement might seem like a constraint for landlords who want to adjust pricing quickly, it also provides a clear and predictable framework that reduces disputes. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date. Georgia doesn't prescribe a specific statutory form for rent increase notices, but a clear written notice delivered by a documented method, personal delivery, certified mail, or other verifiable means, is always recommended. For fixed-term leases, the rent is locked in for the duration of the lease term, unless the lease includes a provision allowing mid-term increases. Common mid-term adjustment provisions include escalation clauses, provisions tied to property tax changes, and CPI-based formulas. Without such a provision, the landlord must wait until the lease expires to negotiate a new rent as part of a renewal or new lease. When a fixed-term lease approaches expiration, the landlord should communicate the proposed new rent well in advance, ideally 60 days or more before the renewal date, to align with the state's notice standard. If the tenant agrees, a new lease is executed at the new rate. If the tenant doesn't agree, the lease expires at its natural end. If the tenant stays and the landlord accepts rent, the tenancy may convert to a month-to-month arrangement, subject to the 60-day notice requirement. For week-to-week tenancies, the notice period for rent changes generally follows the one rental period standard, though the specific requirements depend on the terms of the tenancy and common law principles. Now let's cover the restrictions that apply even without rent control. Rent increases cannot be retaliatory. Georgia doesn't have a comprehensive anti-retaliation statute with specific presumption periods and enumerated protected activities the way some states do. However, courts recognize the common law principle that landlords cannot use rent increases as punishment for tenants exercising their legal rights. If a tenant reports a health or safety violation to a government agency, makes a good faith habitability complaint, or exercises any other legal right, and the landlord responds with a dramatic rent increase, the tenant may have grounds to challenge it. The practical challenge for tenants asserting retaliation in Georgia is that without a statutory presumption, the burden of proving retaliatory intent falls more heavily on the tenant. The tenant must demonstrate through circumstantial evidence, timing, magnitude, the landlord's treatment of other tenants, and the absence of a legitimate business justification, that the increase was motivated by the tenant's protected activity rather than by market conditions. For landlords, this means the legal risk of a retaliation claim is lower in Georgia than in states with strong statutory presumptions, but it's not zero. A rent increase that is clearly timed to punish a tenant, especially when other comparable units aren't receiving similar increases, can still result in legal consequences. Documentation and consistency remain the best protection. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Georgia Fair Housing Law, found in Georgia Code Title 8, Chapter 3, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, or familial status. The Georgia Commission on Equal Opportunity investigates fair housing complaints and can take enforcement action. Some Georgia cities have enacted local anti-discrimination ordinances that provide broader protections. Atlanta has an ordinance that includes protections based on sexual orientation and gender identity. Savannah and other cities may have similar local provisions. Landlords in these cities must comply with both state and local anti-discrimination requirements when implementing rent increases. From a practical standpoint, Georgia's rental market is one of the most dynamic in the Southeast, driven primarily by the Atlanta metropolitan area's explosive growth. Atlanta is the economic engine of the Southeast and has one of the largest and most active rental markets in the country. The city's economy is driven by an extraordinary concentration of corporate headquarters, including Coca-Cola, Delta Airlines, UPS, Home Depot, and dozens of others, along with healthcare, technology, film and entertainment production, higher education, and logistics driven by Hartsfield-Jackson Atlanta International Airport, the busiest airport in the world. Atlanta's rental market has experienced dramatic rent growth, particularly in desirable in-town neighborhoods. Midtown, Buckhead, Old Fourth Ward, West Midtown, and the Beltline corridor have seen some of the most significant increases. The Beltline, Atlanta's transformative trail and transit project, has reshaped real estate values along its path, creating intense demand and substantial rent appreciation in adjacent neighborhoods. However, Atlanta's growth has also brought serious affordability challenges. Longtime residents in historically affordable neighborhoods have faced displacement as rents have risen rapidly. This dynamic has fueled political discussions about housing affordability, tenant protections, and displacement. And while the state's preemption statute prevents local rent control, Atlanta has explored other tools like inclusionary zoning, tenant assistance programs, and anti-displacement measures. The Atlanta suburbs, including Decatur, Marietta, Roswell, Alpharetta, Johns Creek, Sandy Springs, and Smyrna, have strong rental markets driven by families, professionals, and corporate employment. Rents in the northern suburbs tend to be higher, while the southern and eastern suburbs offer more affordable options. Each suburb has its own market dynamics, and landlords should understand the specific conditions in their submarket. Savannah has a distinctive rental market driven by tourism, the Savannah College of Art and Design, the military, including Fort Stewart and Hunter Army Airfield, and the growing port operations. The city's historic district commands premium rents, and the overall market has tightened as Savannah's popularity as a destination has grown. The short-term vacation rental market in Savannah competes with the long-term rental market for available housing. Augusta, home to the Augusta National Golf Club and Fort Eisenhower, has a rental market influenced by the military, healthcare, and the annual Masters tournament. Fort Eisenhower, formerly Fort Gordon, is the Army's cyber center of excellence and has driven significant growth in the area. Military tenants' housing budgets are tied to BAH rates, and landlords near the installation should monitor annual BAH adjustments. Columbus, adjacent to Fort Moore, formerly Fort Benning, has a heavily military-influenced rental market. The base is one of the largest Army installations in the country, and a significant portion of the rental market serves military families. BAH rates are the primary driver of what military tenants can afford. Macon, Albany, Valdosta, and other mid-sized Georgia cities have more moderate rental markets. Valdosta, near Moody Air Force Base, has military-influenced demand. Warner Robins, near Robins Air Force Base, has a rental market significantly driven by the base's civilian and military workforce. Athens, home to the University of Georgia, has a tight student-driven rental market where demand follows the academic calendar. Rents near campus are high relative to the city's size, and rent adjustments in the student market typically occur at the beginning of each lease cycle. The broader Athens market benefits from the university's economic impact and a growing creative economy. Statesboro, home to Georgia Southern University, and Carrollton, home to the University of West Georgia, have smaller student-influenced markets. Rural Georgia has softer rental markets, particularly in the southern and southwestern parts of the state. Population decline in some rural areas has reduced demand, and landlords have limited pricing power. Agricultural communities have rental dynamics tied to farming cycles and food processing employment. One best practice for Georgia landlords: plan your rent increases well in advance to accommodate the 60-day notice requirement. Create a calendar for each unit noting when the notice must be delivered for the increase to take effect at the desired time. The 60-day window is longer than many landlords expect, and missing the deadline delays the increase by a full month. Another best practice? In Atlanta's rapidly evolving market, conduct thorough and current market analyses before implementing increases. Atlanta has seen significant new apartment construction in recent years, adding supply that competes with existing rental stock. While demand has been strong, the additional supply has moderated rent growth in some submarkets. Pricing your units competitively relative to both existing and new construction, and considering factors like location, transit access, amenities, and unit condition, produces better long-term results than simply chasing the highest possible rate. For landlords in military-adjacent communities, Augusta, Columbus, Warner Robins, Valdosta, and others, understanding BAH rates is essential. The military population represents a large and reliable tenant base, but their housing budgets are fixed by the allowance. Pricing above BAH rates narrows your military tenant pool, while pricing at or slightly below the allowance makes your property competitive. BAH rates are adjusted annually, typically announced in December and effective in January, and your pricing strategy should align with these changes. Georgia's film and entertainment industry has created a unique rental dynamic in certain communities. Georgia's generous tax incentives have attracted major film and television productions, including Marvel Studios, Netflix, and numerous other productions, to the Atlanta area and other parts of the state. Production crews often need short-term to medium-term housing during filming, creating temporary demand that can affect local rental markets. Some landlords near major production facilities, like Trilith Studios in Fayetteville or Tyler Perry Studios in Atlanta, have been able to command premium rents from production-related tenants. Georgia requires landlords who own more than 10 units to hold security deposits in an escrow account at a federally regulated depository. The deposit must be returned within 30 days of the tenant vacating. If the landlord fails to provide an itemized statement within 3 business days of the tenant's request, they may lose the right to claim deductions. Georgia's treble damages provision for security deposit violations, up to 3 times the amount wrongfully withheld, makes compliance essential. While these rules don't directly regulate rent increases, landlords should understand that increasing rent doesn't automatically entitle them to collect additional deposit from an existing tenant without a new agreement. For Georgia landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. The authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. Submit increase requests well in advance of the desired effective date. For the complete guide to Georgia rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.